Title is the story of ownership. In earlier chapters, you learned how encumbrances and liens shape the boundaries of ownership. Now we turn to the language of title itself, how the law recognizes ownership, how the public learns about it, and how that ownership moves from one person to another. Along the way, we connect these ideas to practical Arizona details so you can see exactly how transactions are made safe, insurable, and recordable. Legal and equitable title. When people say I hold title, they usually mean they own the full bundle of rights that come with real estate, including the right to possess, use, enjoy, exclude, and convey. More precisely, legal title is the enforceable ownership recognized by the law and confirmed by a deed. Equitable title is the recognized right to obtain legal title under a contract or security instrument. In a deed of trust state like Arizona, the borrower has equitable title, while a neutral trustee holds bare legal title with the power of sale for the lender's benefit. When the loan is paid in full, the beneficiary instructs the trustee to record a deed of reconveyance, which returns legal title to the borrower. Think of legal title as the completed handoff and equitable title as the ticket that guarantees you the handoff when you fulfill the contract. Consider a contract for deed where the buyer moves in and pays over 3 years. During the term, the seller retains legal title while the buyer enjoys possession and equitable title. If the buyer performs, the deed transfers. In a strict foreclosure mortgage arrangement, the lender may hold equitable rights to obtain legal title upon default. In everyday practice, people use title and legal title interchangeably, but knowing the distinction helps you analyze who holds what rights at any moment. How the law decides who owns notice of title. Because real estate lasts longer than any single transaction, disputes can arise over who truly owns a parcel. Our system resolves these questions through notice. Actual notice is direct knowledge, such as reading the seller's deed, attending the closing, or personally observing who is in possession. Constructive notice is legal knowledge imputed to the public because documents are recorded in public records or publicly posted. Recording a deed of trust, or a trustee's sale notice gives constructive notice to the world. Possession itself can operate as constructive notice because a reasonable buyer is expected to visit the property and see who occupies it. Imagine a buyer who checks county records, reviews a title commitment, and visits the property before closing. The records disclose a shared driveway easement, and the driveway physically serving both lots confirms it. The buyer has both constructive notice from the records and actual notice from direct observation. Together, these forms of notice create the most persuasive evidence of ownership and the interests that burden it. Transferring title, voluntary and involuntary alienation. Alienation is the transfer of ownership from one party to another. When an owner chooses to transfer title, it is voluntary alienation, usually by deed during life or by will at death. A private grant by deed conveys legal title now. A will, which takes effect at death, directs who receives the decedent's real property by devise and personal property by bequest or legacy. For a will to be valid, the testator must be competent and of legal age. The will must be written and signed by the testator, and it must be properly witnessed unless it is a valid holographic will. Arizona recognizes holographic wills that are handwritten, dated, and signed by the testator, even without witnesses. A codicil amends a will using the same formalities. Oral nuncupative wills are not valid in Arizona. After death, probate proves the will, pays debts, and distributes the remainder through an executor named in the will or an administrator appointed by the court if none is named. Dedication is a voluntary transfer to a public body for public use, such as a park parcel platted to a city. A gift is a voluntary transfer to a private party without consideration. Involuntary alienation is a transfer without the owner's consent. Title may pass by descent when a person dies intestate under state law, by foreclosure to satisfy a lien, by eminent domain when the government condemns property for public use, by adverse possession when a claimant meets statutory elements, by escheat when an estate has no heirs, or by estoppel when a party's prior conduct prevents them from denying another's rights. Why title insurance exists and how it works. Because recording systems can miss things and people can make mistakes, title insurance protects owners and lenders against covered losses arising from past defects. Unlike other insurance that covers future events, title insurance is backward-looking. A title company searches public records, examines the chain of title, and issues a commitment stating requirements and exceptions. If acceptable, the parties close and the policy issues for a one-time premium paid at closing. An owner's policy protects the buyer and their heirs up to the purchase price for as long as they hold an interest. A lender's policy protects the lender up to the outstanding loan balance and decreases as the loan is paid. Policies list covered risks, exclusions, exceptions, and conditions. Covered risks in a standard ELTA owner's policy can include forged deeds, mistakes in recording or indexing, undisclosed or missing heirs, deeds signed by minors or persons lacking capacity, and certain errors in the chain of title. Exclusions commonly include zoning and governmental regulations unless specifically endorsed. Exceptions listed in Schedule B exclude known items like recorded easements or CC and RS unless cleared or insured over. If the insurer pays a claim, it may exercise subrogation to pursue the party responsible for the loss. In Arizona practice, customary cost allocations can vary by contract and loan type. As a general pattern in finance transactions, the seller often pays the owner's title policy and the buyer pays the lender's policy, while escrow, recording, wire, and courier fees are commonly split or allocated by agreement. Items like inspection fees, repairs, HOA disclosures and transfer fees, taxes, interest prorations, and home warranties are assigned by contract, local custom, or law. With VA loans, certain buyer fees are limited and should be confirmed with the lender. Recording, perfecting, and publishing interests. Recording is how we publish interest to the world and secure priority against later claimants. A valid deed conveys legal title when delivered and accepted, but recording the deed protects that title by giving constructive notice. Deeds of trust, mortgages, liens, easements, and releases should be recorded promptly to secure their place in the priority line. In trustees' sales, the trustee records and mails statutory notices and publishes sale information to impart constructive and actual notice. In day-to-day practice, clean recording is what transforms a private agreement into a public fact that others must respect. Examples that pull it together. A buyer takes title by warranty deed, and the deed is immediately recorded. Months later, a previously undisclosed heir makes a claim to the property. The owner tenders the claim to the title insurer. If covered, the insurer defends title or pays the loss, then subrogates against the party who caused the defect. A seller dedicates a strip along the frontage to the city for a right-of-way during platting. The dedication is shown on the recorded plat, so buyers of lots along the road take subject to the public right-of-way with constructive notice. An Arizona borrower pays off a deed of trust. The beneficiary instructs the trustee to record a deed of reconveyance. Once recorded, the public record shows the lien is satisfied, and legal title is no longer encumbered by that deed of trust. Review summary. Title describes who owns the legal rights in real estate. Legal title is enforceable ownership. Equitable title is the right to obtain legal title under an agreement. Our system relies on notice to determine and protect ownership. Actual notice comes from direct knowledge. Constructive notice arises from public recording and visible possession. Title moves by voluntary alienation through deeds and wills, and by involuntary alienation through legal processes like foreclosure, eminent domain, adverse possession, descent, and escheat. Title insurance protects owners and lenders against covered defects arising from the past using a one-time premium policy that lists covered risks, exclusions, exceptions, and conditions. Recording is essential to publish interests, establish priority, and deliver constructive notice so that future buyers, lenders, and creditors can rely on the public record. Discussion. Why does equitable title matter to a buyer who has not yet received a deed? Answer. Equitable title gives the buyer enforceable rights to obtain legal title upon performance. It supports possession and improvements under the contract, and is typically insurable when conditions are met, bridging the gap between contract and deed. How do actual and constructive notice work together to protect a purchaser? Answer. Actual notice arises from direct knowledge, such as reviewing the deed, title commitment, or walking the property. Constructive notice arises from public recording and visible possession. Together, they reduce surprises, strengthen reliance on the record, and help courts resolve disputes in favor of diligent purchasers. When would a dedication be used instead of a private grant? Answer. Dedication is used when an owner voluntarily conveys land for public purposes, such as roads, parks, or utilities, often shown on a recorded plat. Private grants transfer property between private parties and are not intended for public use. Why does a lender require a separate title policy if the owner already has one? Answer. The owner's policy protects the owner up to the purchase price for covered risks. The lender's policy protects the lender's lien position up to the loan amount and responds to loss scenarios that impair the security for the loan. Each party's risk and limit differ, so separate policies are needed. Closing remarks. Clear. Marketable title is the foundation of every real estate transaction. By understanding the split between legal and equitable title, how notice operates, the ways title moves, the protections provided by title insurance, and the importance of recording, you can guide clients from accepted offer to insurable, recorded ownership. These skills turn abstract legal rules into practical safeguards for buyers, sellers, and lenders alike.